A lot of times there's things they're unaware of that they have to do, or not quite sure, order of operations when they're dealing with things like that, or what they're even allowed to do as that personal representative. So I'm going to help walk you through some of that and give you a little bit of an overview of what that actually looks like, and how it might be a little different than what you would think otherwise. So it's a really good overview just because a lot of people don't really know what that looks like if they've not gone through it before. So again, welcome everybody. I'm attorney Justin Randall with Hooper Law Office. Our topic today is personal representatives and what they need to know about probate. So if you're joining me, you can submit questions to this. So there's a chat function, or a Q&A function rather, where I can see your questions pop up. So if you have any questions that come up as we're going through this is meant to be interactive. But please feel free to submit those. Another thing too is you're going to be receiving some materials from this as well. One of them I have right here with me is a kind of a little, you can't really see it necessarily, but a chart about what goes through probate and how things go through probate and what may not go through probate when you're dealing with someone's estate. So it's not obviously an exhaustive list, but it's a good list for you to look at it to get a little bit of an understanding of what actually happens and where some difficulty can come up. But another thing you'll receive too is a feedback form, which it does give you a place if you would like to set aside time to talk to any of us. Our initial consultations are complimentary. They don't cost you anything to talk to us. We set them up for about 2 hours. So if you need any assistance with probate or really any sort of estate planning issue or questions that you have, please feel free to fill that out, and then we can set aside a time to talk. Okay, so to get started, when we're talking about probate, a lot of people misunderstand what probate even is, or don't know what it actually is. I sometimes do get the question of what even is probate. What probate is the process where somebody's estate is dealt with through the court system, right? So probate is a court process. If it's informally done, meaning you're not actually standing in front of a judge, informal probate does not require like going and making appearances in court and doing all of that. It's often done just by filing things with the register in probate. But how probate works is the personal representative named in somebody's will has to initiate that process by filing the will with probate first. And this is where the confusion tends to come up with a lot of people, is they think that probate is, if they know about probate, is they think that it's only for people who don't have a will, or only for people who don't have a plan at all. And that is unfortunately not the case if that's what they're hoping is true. Wills only direct probate assets, and they only direct those assets once the wills are submitted to probate and that process has been started. So you could not, for example, take a will down to the bank and say, see, I'm the personal representative. I can do all of these things, and this is how the assets are supposed to go. That's not how that would work. Unfortunately, you would have to first get the authority from the court to act as the personal representative. So how that works is, and this is a sort of the time frame of which this is supposed to occur, is usually within 30 days of someone's passing, you're supposed to file the will. I say 30 days within passing, but it's really 30 days within the time frame that person has received the will. So if you obviously didn't have it on hand right away, it's not 30 days from the date of death. But and that's honestly, people sometimes don't even meet that guideline, but you are supposed to file it that quickly. So once the will is filed with probate, that's when the court will look at who's nominated in that will as the personal representative. I say nominated because that's really all that is when you put that in a will. It's no different than when you name or nominate guardians in your will. Those people don't automatically become the guardians of your children, right? They have to be approved by the court first. So as a personal representative, just because somebody is named first in line in that list does not automatically mean they will be approved by the court. More often than not, they are, just because if there's not a good reason not to have that person act, there's no concern about fraud, or that they're, not doing things according to the way the will is directing assets. For the most part, more often than not, there's no reason to not have that person be approved. But it's not an immediate approval either. The court has to first give notice to all of what they call the interested parties. What that means is a good way to remember that, or a very simplified definition of that, is who are the beneficiaries of the will, first and foremost, who would be the beneficiaries of the will if that will were for some reason invalidated, like the person didn't have capacity to sign, who would inherit otherwise, sometimes who would inherit even if these kids were disinherited, right? Those people have to be given notice first that this is being filed. And if those people sign off on that person being approved as the personal representative, it's generally a pretty quick approval process. A couple of weeks would be a relatively normal time frame for that. But it can take longer if anybody objects to that approval. And that, anytime anybody objects to anything in court, it's obviously going to take longer than it would if nobody objected. So if that's a concern, it's good to know about that in advance, because it can sort of temper your expectations a little bit of how long this process might take. But if once that personal representative is approved by the court, once they've gotten what's called a domiciliary letter, which is essentially like a financial power of attorney for the estate, is the way I think about it, right? It's giving that person the authority and the proof that they have that authority that they say they do. So I mentioned earlier, one of the things that somebody would not be able to do right away is just go down to the bank as a personal representative, for example, and say, I can act in this role. They would need, the bank would say, come back when you have the right documentation, right? So what that documentation would be is the domiciliary letter. So that's what then gives that personal representative the ability to go down to the bank and say, I can act in this role, and I have the authority to start doing these things. In the meantime, before that happens, though, some of those accounts, or most of those accounts, will be frozen. You can't have access as a power of attorney, for example, after someone's passed away, to their bank account, because powers of attorney end at death. And this is another really big misconception people have. Even if it's the same person acting, they may think, if I'm that financial power of attorney, I can just continue that on and do all of these things. And that's not the case. So bank accounts would be initially frozen at death if they're going to someone's estate, just so that nobody can, commit fraud or do anything like that. So that's not as big of a problem as it sounds either. I think a lot of people, that worries a lot of people, thinking, well, how do I pay bills in the meantime? How do I do all of these things? Creditors and, funeral homes, like all these places that, you're going to have expenses. They know that when someone passes away, they're not going to get paid immediately. They know that it is going to take some time. And even if they try to hound somebody and say, you have to pay us, they have to wait. There's a the probate court process deals with creditors. So you want to do that through that process rather than worry about paying things immediately if that's a concern. It's not as scary as it sounds, for example, that those accounts are frozen. It's not like it'll be forever until they get access again, or that somebody's going to get in trouble for not paying these bills. It's sometimes this happens where, they have to wait, and they know about that. So it's not as concerning as it sounds. But once the personal representative is approved, those accounts are unfrozen, right? They have the access to open estate accounts. They have the ability to start paying any sort of immediate bills that are necessary. But as a personal representative, you don't want to just pay all the bills right away either, which sounds counterintuitive. I know, as a society, we like to pay our bills. We like to not have debt. We like to get around those sorts of things and deal with them as quickly as possible. But you don't actually want to pay all of the expenses that are coming in right away. Things like creditor bills or hospital bills, things like that. You want to first make sure that the proper process is being followed. So what that means is you have to give notice to creditors that somebody has passed away and they can make a claim against the estate. So what that means is, if you know about the creditor, so like if we were in the hospital, a mom or dad was in the hospital right before they passed away, you probably know that there's going to be a bill there, whether it's through the insurance or some sort of deductible or whatever. There's always something. So, with creditors like that you know about, you have to give direct notice to them. You can't just sort of give a nebulous public notice saying, see, this person passed. You do have to give them direct notice. But if you don't know about all the creditors, which I mean is true of most people, and even if you think you know about all of them, you still have to give public notice that this person has passed away, and that if there are any creditors out there that did not receive direct notice that were unknown, you have this period of time to file a claim with the estate. That time frame is about 90 days. So it's about 3 months that somebody has to wait after they've opened a probate before that time period lapses, where creditors have that much time to make a claim against the estate. But if they don't file a claim by the end of that time period, and if they weren't supposed to get direct notice prior to that, if they weren't, or if they were known and didn't get direct notice, that's a different story. But if that claim, if everybody was given notice and they did not file a claim against the estate, their claim may not be valid anymore. So there's been instances, for example, where we've had, we've given notice and people didn't file a claim until months after that time period lapsed, and their claim didn't matter anymore because the court said you had this period of time and you didn't follow the time frame, so that's too bad. So the reason that I'm saying you want to hold off paying those bills, even if you know about them, is the personal representative's duty is not just to pay the bills, but also to maximize the value of the estate. So what that means is if you're paying bills where they otherwise wouldn't have had to be paid because that person didn't, that person being the creditor didn't follow the proper chain of events, they didn't file their claim against the estate, well, you're paying a bill that otherwise would have been absolved. So your job is to maximize the value of the estate, which means following all the right steps, right? Giving the notice to those creditors, doing the public notice. But if somebody doesn't file their claim, that's on the creditor. That's not on you as personal representative. So, that's actually better for the beneficiaries then, that creditor missed their time frame and you don't have to pay that bill anymore. So it's one of those things where it's kind of sort of counterintuitive to what we think about. We're all, understandably afraid legally of getting in trouble with things, of having liability. But this is one of the rare instances where, as long as you're following the proper steps, if they don't do their end of that, then you may not have to pay that bill. So that's why you don't pay everything right away, even when everything is unfrozen. I mean, there's some bills where that's, totally fine to pay the bill. Like if the home has a heating bill that month, you're not going to not pay the heating bill, right? Or if there's a utility bill of any kind, those sorts of things are a little different. But, larger hospital bills, mortgages on the property, student loans, right? Whatever it might be. Those sorts of things you want to give notice, but not necessarily pay off right away, even if you could. So after that public notice is given, after that time period's taken care of, that's when the personal representative's job is to make sure that they have an accurate inventory. They have, here are the assets of the estate, which you'd actually do before even the notice, but make sure everything is accounted for, and then see how things are supposed to be divided up. Are there specific dollar amounts that are supposed to go out first? Is there, certain percentages that people are supposed to get? Of those percentages, are there certain ways that they're supposed to inherit it? Meaning, is there trust being set up for a minor, or does a beneficiary have some sort of like supplemental needs, where they need a supplemental needs trust rather than just inheriting it in their own name to not cause problems for like means tested benefits? That's where after all the creditor notice is done, you're supposed to look at that and make sure that's followed. That's the personal representative's duty to follow that. So it's not discretionary to do that. They have to follow the way, to the best of their ability, the way the will is supposed to be divided. Now, this is where issues can come up though. So this is also where this chart that I mentioned earlier, the what goes through probate and what doesn't, is incredibly helpful, because I think it highlights how things can go wrong when someone is trying to follow the will to the best of their ability, but they may not be able to. So remember, as I mentioned earlier, that the will only directs probate assets. It does not direct assets outside of probate. So that can be a really, really big issue if there's very little going through probate. Somebody has a will, but they have things directed outside of probate, or they have things that they think will help, simplify the probate, but actually end up creating issues. So what goes through probate is if something is specifically left to someone's estate after they pass away, that would send it through probate. Or if there are no beneficiary designations on it, it would go through probate. And assuming it's not owned by, for example, like a revocable trust or another type of trust, if it's just owned by the person and there's no beneficiary designations on it, that will go through probate. But what happens more often than not, I would say, especially these days, is people put beneficiary designations on things. They put payable on death or transfer on death on accounts. And there's nothing inherently wrong with doing that. The problem comes in, though, is when somebody is, their entire estate plan intends to use probate, meaning they have a will and their will only directs probate assets, but then they have all of their finances avoid probate. Or a more common example would be the real estate goes through probate and none of the liquid cash does, right? So this is where issues come up for you as a personal representative. If you as a personal representative, let's say in one instance, you are not even a beneficiary of the trust. Well, you as personal representative only have access to the probate assets. So if you're not also a beneficiary, you may not have liquid cash available to pay ongoing expenses or to pay creditors or, any of the sorts of reasons you would need some sort of liquid cash in someone's probate estate. Things like, are there ongoing utility bills for the real estate, right? If it's just the home in probate and you have no money in probate to deal with that, are you paying that fee? Possibly. If you're the personal representative, you could be reimbursed for that expense, but maybe not if there's no money to do that, right? That could be an issue. And the issue would be if the money itself had all been given out to the beneficiaries already, those beneficiaries are not obligated to give the money back to help pay those expenses. So this becomes a really big issue where somebody says, well, why would I give my money back to help pay those expenses? I don't have to. But this as a personal representative puts you in a very difficult position of trying to deal with this expense that's come up where you don't have the funds to do so. So it's just not an ideal situation if that's the case. You always want some amount of liquid cash to go through probate to help cover those expenses. There are certainly things that you don't want to go through probate. If somebody has an IRA or a 401k, it's perfectly fine for that not to go through the probate process for most people, because when you do that, it could create a 5-year payout for that asset, which means expedited taxes on it if it's a pre-tax account. So, there are reasons that some accounts would not go through probate, but you always want to make sure when you're doing this planning that you walk through what should go through probate, or make sure that there is enough liquid cash available to pay those expenses. The other sort of concern that can come up for people, I think, is when they have the personal representative as one of the beneficiaries as well, but they still beneficiary designate everything outside of probate. So that sounds like, well, this personal representative would now have liquid cash available to pay these expenses, and that's true. But if there's usually one of two ways that this goes wrong. The first would be if everything's split equally. Let's say there's 4 beneficiaries and the personal representative is one of them. Well, their fourth has already come to them this way then, so they have that money available. But if they're using their share to pay those expenses, those other beneficiaries are not obligated to share in those expenses, and they're also not obligated to reimburse the personal representative. So where this could become a really big issue, obviously, is if the estate plan was set up so that everyone gets everything equally, but then one person ends up actually keeping less of it because they paid more of those expenses, then the goals were not actually met, right? If 25% was what everyone was supposed to get, but then the personal representative as a beneficiary only got to keep 12% or whatever it would be, that's not what that person intended. So it's an unintended consequence of having everything avoid probate, even when you're trying to use a will. The other alternative is, and this is where problems also can come up, is if somebody leaves everything to the personal representative as a beneficiary because some well-intentioned person told them this will make it a lot easier for them to pay expenses. Then they have access to everything, and then they can divide it up. This can create problems in one of two ways. One, now that person as a beneficiary owns those assets. So they are now under no obligation to follow the will with those assets, right? They do not have to divide those up in accordance with the will because they're not probate assets. Two, the other alternative with that is maybe they have some sort of legal reason they can't give up those assets, right? So to give you a more real world concrete example of that, let's say that personal representative is in the middle of a bankruptcy when this happens themselves, they're filing bankruptcy. Well, if they are the beneficiary of those assets, that becomes their money. It's not available for the estate. It's not the estate's money. There's not some sort of special protection in place where they suddenly, that's protected because they're supposed to follow the will. If it becomes their money, the problem you're going to have is if somebody is going through a bankruptcy, it's available for that now. They have to pay it to their bankruptcy creditors and make sure that they get what they can get from it. If they try to transfer things, try to divide it up in accordance with the will, even if they're just trying to do the right thing by doing that. There is such a thing in bankruptcy called a fraudulent conveyance, right? Which doesn't necessarily mean you're intentionally, you're not trying to be committing fraud or anything like that, but it means that you moved assets that were otherwise available for paying off your creditors. So if the personal representative has any of those sorts of liabilities in their life, and it's not just bankruptcy, but it could be they're on Medicaid, right? And they're means tested on that. If they give anything away for that, they lose their benefits. So you don't want to put someone in a position where they have to choose between following your wishes and causing themselves financial harm by doing so too. So the way that a probate estate should be set up, if you're intending to use the terms of the will, is make sure that there is enough, as I mentioned earlier, is enough in the probate estate to pay those expenses. Make sure that you have cash that the personal representative has access to as part of the probate estate, where they can pay those expenses. If there's anything left over in that account or those funds, after all those expenses are paid, then they have to divide it up equally. So that takes care of a lot of those concerns I mentioned, where one, again, the personal representative does not necessarily have discretion in how those funds are divided up. So if it says equally, they have to do that, otherwise they're in trouble, right? The other part of that is, as if the money is part of your probate estate or this person's probate estate, not the personal representative's personal assets, then their creditors, it's not their money. So their creditors can't get it, right? Not then anyway. Not if they're a beneficiary and there's not proper planning to deal with creditor protection, that's a different story. But during the probate process, the funds of the estate are not available to the beneficiary's creditors. They're not available to the personal representative's creditors, so that it deals with a lot of those sorts of concerns that can come up. I think the problem that comes up a lot is someone has a will drawn up for them. They don't understand that those assets have to go, or the only way that will is going to direct anything is through probate. They don't understand that or don't know it, or were told incorrectly sometimes. But then they have all of their goal is to avoid probate still. So they want all of these assets to be left directly to the beneficiaries. So what that would tell me, though, is if somebody is trying to avoid probate like that, but also has a will as their only estate planning document, tells me they don't have the right estate plan, because wills are not designed to avoid probate. They specifically only control probate assets and only direct or have any authority in the probate process. So you cannot, if your goal is to avoid probate, a will as the main document might not be the right plan for you. And if you've ever attended any of our other talks, this is where we generally talk about how if someone is trying to avoid probate, that might be where trusts are a better alternative for them, because it still gives all of that same sort of planning you can get in a will, but also the avoidance of probate. So, there's nothing wrong with going through probate for somebody if it makes sense for their planning. Probate on average, time frame wise, can take about a year to a year and a half on average. That's a pretty standard number. Sometimes longer if there's things that are holding things up. The court doesn't like when that happens. They get very antsy when that's happening, understandably so. But it can be things like, although in today's housing market, this is probably not a good example anymore, but sometimes the home takes longer to sell than you'd expect, or there's something going on with that they need to fix it up before it's sold, right? And that takes a long time. That can obviously make a probate take longer than a year and a half, depending on those circumstances. If people are objecting to things or fighting over things, this is going to take longer than a year and a half. And that's not because people don't want this done sooner. It's because court processes take a long time. You have to wait for your date in court. You have to file by a certain date, but then you have to wait to hear back. So it's a lot of hurry up and wait, even in a pretty standard probate. But if somebody is appearing in court, they're fighting over things, that's an entirely different issue, right? They're going to take longer than that, especially if they can't come to an agreement. If somebody's unhappy with the way things are being done, as the personal representative is being sued by the beneficiaries, right, or whatever it might be. So it's just something to be very aware of as a time frame. In general, when you're talking about a probate, in terms of a cost to the estate, you're generally looking at, with attorney's fees and everything like that, about 3 to 5% of the value of that estate, of the probate assets in particular. That's generally a pretty standard number. So there's reasons that people want to avoid probate, right? I mean, it doesn't make sense to use probate for everybody. So, when someone asks, do I use a will or do I use a trust? My first question is going to be, what do you want to happen after you pass away, right? Which process are you looking to use? What are your goals? I don't care if they have $100 million or if they have $100,000, it doesn't matter. If their goals are, I don't want to go through probate, well, then that tells you maybe it's not, maybe a will-based plan is not the right tool for you. A common question with trust is, well, I heard you still have wills when you have a trust, and that's true. But those wills are they're called pour over wills. The whole point of those wills is to say, if I were to pass away and something wasn't properly titled in the name of my trust or wasn't beneficiary designated to my trust, the pour over will, it's kind of like, if you think of a pitcher pouring something over, that's basically what it does. A pitcher of water pouring the assets back into the trust is my mental image of it. Anyway, you can use a different one if that's better for your understanding. But that's why those people still have wills, is it's a backup plan. You're not trying to use the will. If you're using the will with somebody's trust-based plan, that means probably something either didn't go quite the way it was expected, or there was a very specific reason they were using the will for one of those assets. Where you have to use probate and where probate is the right tool for somebody to use would be if you have minor kids. Like I mentioned earlier, you have to nominate guardians in a will. I've seen people try to do that in a trust, but that wouldn't mean anything. You have to nominate them in the will, because the court, much like the personal representative, has to approve those people to make sure they're the right fit. So that's a really big reason that somebody's going to use some level of probate, is if they have minor kids and then they pass away, you need guardians in the will. Another reason is when, we've talked a lot about creditors today. If somebody owes more money than their estate has, probate is a really good tool to use for that type of situation, because the creditors, it's almost like a bankruptcy for that person's estate. Then they can take what they can get in order of priority and how much, based off how much money there is and how much was owed and all of that. But then as long as you as the personal representative have done all of those steps properly, they can't try to say that you didn't do something right. And that in particular helps that personal representative be comfortable knowing, okay, I didn't do anything wrong here. It's not your fault as personal representative that somebody had more debt than they had assets, right? So they can't come after you as long as you did that properly. So that's one thing to remember with that type of situation. And obviously it doesn't come up all that often, thankfully, but when it does, it's a really good use of probate. There are also some types of long-term care plans that we would use probate for intentionally, because there are certain types of trusts for spouses, for example, that according to our rules through Wisconsin Medicaid, they need to be set up in a will. Those types of trusts do. So that's another common reason, and probably one of the most common reasons I would use probate for somebody, for example, is if they're worried about long-term care. That can be an option that we would set up for that person. But again, that's not going to apply to everybody. It depends very heavily on that person's situation. But if somebody just says, pretty standard situation, my kids are all adults, I'm not worried about long-term care planning, and I don't want to go through probate, well, I mean, then while that person is alive, it's a good time to take a look at their estate plan and say, does this make sense? Are we doing this in the most efficient way? Because if not, if it's the goal is to avoid probate, but they only have a will, that's often where these types of issues come up, where not all of the money is in the right place, or it doesn't go according to plan, or somebody does spend more of their assets than they're otherwise thinking they would have to in terms of their share, of the estate. So, if you're using a will, the most important thing I can say is, if that is your intent to use that will, make sure your estate is properly directed, and work with an office that will help you do that. Don't try to. A lot of attorneys, unfortunately, out there, they just don't have the staffing to do this, but they'll say, here's how you do it, but go do it. And if you don't do it, that's on you, right? So, for example, we specifically help our clients do that alignment of their estate to make sure that works. I'm not seeing any questions, but so one thing I'll let you know before I go here is, and let you guys go, is our next week, our topic for our webinar is protecting the family farm, or our legendary planning. We like our puns here, so it doesn't have to be a dairy farm, by the way, but obviously we like our puns. So that's our topic for next week, is family farm planning and making sure that it's passed on properly, or if there are like long-term care concerns, that's dealt with effectively. And then just one last reminder that if you'd like us to reach out to you to set up a time to talk to one of our attorneys, please feel free to fill out that feedback form and let us know that you'd like to set aside time to talk. And again, those are complimentary, and we set them up for about 2 hours. So with that, I will let you guys go and enjoy the rest of your day. And thanks.